Okay, it is 7 o'clock. We'll call the meeting to order, and we'll start with a Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Before I get into the agenda, I'd like to welcome our newest commissioner, Kenneth Chip Landers, appointed by in District 3 by County Commissioner Susan Adams.
Mr. Zork, actually.
Oh, Mr. Zork. Oh, really? Okay, is Susan Adams, who did Susan? Pardon?
Susan Adams would be District 1.
Yeah.
Okay. Okay, and one of you are appointed by Susan?
No, you love Leslie Davis, but now she's...
Yeah. Okay. Okay, I got it. Okay, well, in any event, Chip, welcome to our Planning and Zoning Commission. The next item on our agenda is item 2, which is additions or deletions to the agenda. Mr. Bowling, do we have any? Members of the Commission have any suggested changes? If not, we'll move forward on the agenda. Next item is item 3, approval of the minutes of October 13, 2016. Have you read them, and do we have a motion?
Move to approve.
Dr. Day made the motion to approve. Do we have a second?
Second.
And Mr. Rednauer made the motion for a second. Any discussion? All in favor of the motion, please signify by aye.
Aye.
Aye. Any opposed? Hearing none, that motion carries unanimously. Next item on the agenda is on the consent agenda, item 4A, and I'll go ahead and read it into the record. It's Farnsworth, Oslo, and 27th, request for preliminary plat approval for a 4-lot commercial subdivision. Oslo 17 LLC is the owner. Schilke Biddle and Stoddard LLC is the agent. It's located at the southwest corner of Oslo Road and 27th Avenue Southwest. The zonings are CL, limited commercial, and RS3, residential single family, up to 3 units per acre. The land use designations are CI, commercial industrial, and L2, low density residential 2, which is up to 6 units per acre. It is quasi-judicial. It is on the consent agenda. Because it is quasi-judicial, I will ask if any member of the Commission has engaged in any ex parte communications, site visits, independent investigations, or is aware of any other fact or conflict which would prevent the Commissioners from deciding this on a fair basis based on the evidence and on the law. Hearing none, I'll assume there is nothing. Does any Commissioner have any questions of staff? I do have one question. And again, this is probably the general education of Plaquemine again, but it's a commercial subdivision, and as I understand it, roughly half the property, the northern half is zoned limited commercial and has a commercial industrial land use designation. The south half of the project is actually zoned residential and has a residential land use designation. And I realize the south half of the property is hosting or housing, if you will, the detention area, the wetland mitigation, and the conservation. And I just want to make sure that those types of, I'll call them accessory uses for lack of a better word, to a commercial project are permitted in residentially zoned property.
Thank you, Mr. Chairman. Stan Bowling, Community Development Director. It's a great question. It comes up periodically, and in the code and in practice, those types of uses of the residentially zoned portion of the project are allowed. Stormwater facilities are allowed, conservation areas, open space areas, that sort of thing. So it's not uncommon. We have many commercial projects throughout the county that may have their stormwater in a residentially designated property, and what that winds up doing is actually providing. So the result of it, the answer is yes, because we don't allow hard improvements. We wouldn't allow the parking area and driveways. We would not allow the buildings, certainly, those that are directly commercial. But stormwater ponds, conservation areas, green open space is certainly allowed in residential districts. And the result in practice is you wind up with more separation between the commercial project and adjacent residential, because you're actually providing a more extended buffer, usually by kind of throwing in the stormwater. But it's also a more efficient way for the landowner, the developer, because he's using residential property and putting zero density on it, zero pavement, zero buildings on it, and it's open space.
Okay. Any other questions or comments concerning this item? If not, staff has recommended that we grant the preliminary plat approval with conditions listed on your memo. Do we have a motion concerning the recommendation?
Motion to approve with staff recommendations.
By Mr. Brognano. Do we have a second? Second by Mr. Landers. Any discussion? If not, all in favor of the motion, please signify by aye. Aye. Any opposed? Hearing none, that motion passes unanimously. Okay, the next item on the agenda is item 5A, which is also quasi-judicial. It is not a consent item. I'll read it into the record. It is the River Preserve request for major site plan approval for a 96-unit multifamily development. Indian River Preserve LLC is the owner. Carter Associates, Inc. is the agent. It's located on the east side of US 1, approximately 1,500 feet north of Barber Street. The zoning is RM6, residential multifamily, up to 6 units per acre. The land use designation is L2, low density 2, which is up to 6 units per acre. The density is 6 units per acre, which is 96 units based on 16 acres of the project. As I said, it is quasi-judicial, so once again, I'll ask if any members have engaged in any ex parte communications, site visits, independent investigations, or is any member aware of any conflict or other matter which would prevent them from deciding this matter fairly based on the law and on the evidence? Hearing none, we will take that to mean there are no such activities. We will start then by opening the hearing and asking that anybody who intends to testify in this hearing please stand, and Madam Clerk, would you please administer the oath?
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth? Thank you.
Mr. Bowling, we'll start with the county.
Thank you, Mr. Chairman. I will lateral to John McCoy, Chief of Current Development.
For the record, John McCoy with the County Planning Department. This is an application for the River Preserve, and it's a reapproval of a project that you all saw in 2013. Site plan approvals are good for 3 years with an extension. Site plan approval vests when construction commences. Construction was not commenced on this particular plan, so reapproval is necessary, and they're proposing the same project, same design that was approved in 2013. The project is located on the east side of US 1, just south of 99th Street, and really what we're looking at here is phase 2 is where the actual reapproval is occurring. Phase 1 construction commenced, so that site plan remains valid. This is an overall aerial of the site, and you can see some of the buildings in phase 2. In phase 1, you can see some of the improvements and the site plan overlaid, and in phase 2, you can see the site plan overlaid on the improvements. This is a close-up aerial of the phase 1 development, and you can see that the lakes and the roads are existing, and those improvements were constructed. And those improvements were constructed with a previous design, and let me just talk about that design for a second. That design was for a single-family subdivision, was approved in 2003. That preliminary plat expired because a final plat wasn't established. They didn't get a completion of construction, and in 2013 is when they decided to do a multifamily design, and that was the design that was approved in 2013 and the design that they're seeking reapproval of tonight. With that, I'd like to move on to the aerial for the excuse me, the overall site plan area. Went backwards there for a second. And again, this shows the layout of the overall, shows the west half with the multifamily and east half with the condominiums that are under construction. There is a parcel boundary between the in phase 1, so a unity of title will be required for that area. And this shows the layout, and it's essentially 96 units on 16 acres at an overall density of 6 units per acre. While the infrastructure's in phase one, as far as the roads and the drainage, it hasn't been inspected and improved. So phase one is dependent upon phase two for some of those infrastructure aspects, namely utilities going through phase one, roadways, water and sewer. So all that will need to be inspected and approved prior to any COs, whether it be in phase two or phase one. And right now phase one is ahead, although construction has been suspended in phase one. As far as traffic circulation goes, the driveway is served by a southbound left turn lane at a median opening on US 1 and a northbound right turn lane. Those improvements have been constructed, but again, they haven't been inspected and accepted by the DOT. So again, that would need to occur prior to the first certificate of occupancy. The other item I'd like to point out is it's a single point of access. It's a fair number of units. There is an emergency access that actually comes off the south and extends into a DOT drainage right-of-way. It's a stabilized access. That's been approved by emergency services, and our engineering department is seeking a reapproval or reconfirmation from the DOT that they're okay with that stabilized emergency access within the right-of-way, and the applicant's going to provide that prior to site plan release. As far as the stormwater plan, again, the stormwater system was built with the subdivision improvements, is in place, and essentially the multifamily layout's been designed around the existing infrastructure, the roadways and the lakes, and again, this was looked at in 2013. As far as a landscape plan, there's a landscape plan for the 96 acres, and one of the improvements that has to be in prior to any certificate of occupancy in this phase is the arterial road buffer, which is essentially the part in green. That's the landscaping between US 1 and the project, and that would be in prior to the first certificate of occupancy. For environmental issues, there's really 3 and 2 are indicated in general on the slide. There's an upland conservation easement, which is just basically a sliver along the very, what I'll call the eastern part of the wetlands or the western part of the developed area. And that needs to be granted to the county prior to the issuance of a land clearing tree removal permit prior to site plan release. And that's an upland conservation easement. The blue are wetlands easements, and those are part of the St. John's permit. Those need to be dedicated to the St. John's at the same timing. The other environmental aspect is tree mitigation. Some of the trees that will be removed in phase 2 do require mitigation, and there are 2 aspects to that. One is that there's a fee in lieu of it needs to be paid prior to the permit being issued. Secondly, if the applicant opts to plant trees for mitigation, those trees need to be planted prior to the first certificate of occupancy. With that, I would like to get to the recommendation. Staff does recommend approval of the plans with the conditions as noted in the staff report. Thank you.
Any questions or comments by commissioners to county staff?
Yeah, I can see that the development bisects 2 mosquito control impoundments, one to the north and one to the south. And that upland easement, is that area going to be flooded? The area just to the east of the upland easement? And looking at that aerial?
This
No,
pond
no,
or this pond?
that part right there. Is that flooded?
To my knowledge, it's not flooded. I believe there is a water control, so I believe there's water that will eventually find its way in, find its way through, and I believe the elevation is controlled. And we have, mosquito control does review these plans. They have been and they're seeking access, and they do. We'll take a look and inspect this on a regular basis.
Yeah, that was my question. I mean, it looks like, I suspect that the impoundments to the north and the south are well managed, and it looks like that area around that upland easement is going to be prime, possibly prime mosquito habitat. So if mosquito control is involved, that's good.
Correct, and they have been involved throughout the
Yeah,
process.
good. That's really good.
So, to follow up with that, they are interconnected, so there's some movement of water, so there's no stagnation there?
As I remember the plan, there's movement of water from this area into this area. The water from this area generally is going to move towards the Indian River. So there'll be some drainage that comes into here. Water's not moving from east to west at this point, but it is essentially moving into this area, and this area will be monitored by mosquito control as far as the ability to read any mosquitoes and treat it if necessary.
The road buffer, the 90-foot wide road buffer along US 1, the north end of that, it looks like most of that buffer area will consist of that drainage, that stormwater lake. I don't think necessarily of a lake as a buffer with the US 1, but is there enough remaining land there so that there will be in fact an effective buffer?
Oh, yes, there is. And what happens is there's a wall that will provide a physical buffer in closest proximity to US 1. And then as you come back, there are ability to do some landscaping on the east and west side of the ponds. So again, looking over the wall, you should see some trees and then the project beyond that.
Where do the three, I remember reading in here someplace, it said the three stormwater lakes are interconnected and are draining into an area, which I'm thinking is that wetland area in the center, is it? Or
Correct.
where are those three lakes draining to?
Correct. These three ponds are interconnected via a series of culverts. And if I'm remembering correctly, once they reach a certain control elevation, that water will essentially hydrate the wetland. Once it's treated and reaches a certain elevation, will hydrate this wetland. It will may flow, and again, depending upon the volume of water, through here and then out of this wetland.
To where?
To the east. So, all this water will go east. This, as I remember, is interconnected, so there'll be flushing back and forth, tidal flushing. But this is non-tidal.
So the likelihood of any of the road debris?
Excuse me, is your microphone on, Mr. Linders? Look for the green light.
Yeah, sorry
There
about
you
that.
go.
So the likelihood of any of the rainwater coming off the road, and petroleum products and all that are draining into the wetlands area, but the chance of that draining into the river, it's not connected in any form.
It's not that it's not connected, but there are a series of filters and connections before it gets to that point.
Okay, thank you.
Yeah.
Any other questions by the commission? If not, I know the applicant is here. Would the applicant like to make any presentation?
Good evening. My name is John Blum. I'm an engineer with Carter Associates. I don't have a presentation, but I'll try to clarify some of the questions. The middle blue easement area is not necessarily a wetland. It's more of an oak hammock. So there is no connected drainage through that part. The only connected drainage is, John, can you go back to that exhibit with the lakes shown? Yeah. So the pond along US 1 is connected to the center pond in the loop via culvert.
It actually has an arrow.
Right, and then there's an outfall structure in that main lake that goes into, I can't read which storm, where his cursor is, lake number 3, I guess.
Number 3?
It's 3.
3. And then from there, there's a culvert that goes to the east, and if you can go back to that last exhibit. Then it connects into, it bypasses that with a culvert. Move your cursor to the east further, and then it comes right into there. And then that first segment of blue area that's kind of bisected with that dark line is a wetland mitigation area. So the water flows into there, hydrates that wetland, and then it goes to the east of that into a more deeper water body, stormwater pond. And then from there is the outfall into the river that goes between two of those condominium buildings. So like John said, it is tidal, but as far as that main center area, that is not a hydrated wetland, it's an oak-hammock. That is preserved in conservation.
This isn't, that very first lake all the way to the east isn't designed to take runoff from US 1, is it?
No.
Yeah.
No, it is not.
It's on the inside of the wall.
Yeah.
Right. It's basically there for added storage capacity.
Anything else you'd like to add, Mr. Blum?
No, sir.
Any questions of Mr. Blum? And do you have any questions of county staff, or does county staff have any questions of Mr. Blum?
I do not.
Okay. Thank you very much.
Thank you.
And Mr. Bowling, anything further from county staff? Okay, we'll go ahead and close the public quasi-hearing, quasi-judicial hearing. Gentlemen, what is your pleasure?
Make a motion to approve the staff recommendations.
That was Mr. Brognano. Do we have a second?
Second.
Mr. Rednauer made the second. Any further discussion? If not, all in favor of the motion, please signify by aye. Aye. Any opposed? Hearing none, that motion carries unanimously. Thank you. Okay, next item on the agenda is a legislative matter, item 6A. This is a public hearing. It's consideration of proposed amendments to the county sign regulations, land development regulations, Chapter 901 definitions, Chapter 956 sign regulations, and Chapter 912 single-family development. It's a modification to regulations for temporary signs and various sign definitions. It is legislative. Mr. Bowling?
Thank you, Mr. Chairman. Our sign expert on staff, Roland DuBois, Chief of Environmental Planning and Code Enforcement, will be giving the presentation, and I'll be available for questions, as well as Mr. DeBrawl.
Very good.
Thank you, Mr. Chairman. For the record, I'm Roland DuBois, Chief of County Environmental Planning and Code Enforcement. As Stan indicated, this is a proposed amendments to the county sign regulations. Just a little background. County sign ordinance that we have now was substantially developed back in the mid-1980s after some extensive public workshops. There have been some changes over the years, but it's essentially as it was developed back in the 80s. The ordinance regulates signs, type, size, number, location. It distinguishes and has different regulations depending on whether the signs are on-premises signs, off-premise, freestanding or facade signs, permanent signs, and temporary signs. Some signs are prohibited, such as banners and animated signs. Other signs are allowed without permit, such as garage sale signs or real estate signs. The objectives of the ordinance as specified in the current Chapter 956 are to avoid excessive sign proliferation and clutter, to accommodate information for the public, protect property values, create an attractive business climate, protect the community's appearance, and improve vehicular and pedestrian safety. The reason we're here today is there was a U.S. Supreme Court decision back in 2015, a case known as Reed versus Town of Gilbert in Arizona. In that case, which made its way up to the Supreme Court, a church contended that the Town of Gilbert regulated signs differently based on the content of the sign, and they contended that that violated freedom of speech under the First Amendment of the U.S. Constitution. The Supreme Court, in its decision, sided with the church. It invalidated the town's sign code as content-based regulation of speech. They found that the town's distinctions among different types of signs were content-based and did not satisfy the strict scrutiny, as they called it. During the decision, the court did clarify that local governments could regulate sign size, location, including by zoning district, physical characteristics, and duration of display, but on a content-neutral basis. When this decision came out, particularly for planners across the country and those localities who regulate signs, it had broad implications because most sign ordinances, local government sign-off ordinances, have some level of content-based regulation. For example, right now in our code, which I'll reference, we regulate garage sale signs a little differently than we regulate real estate signs. And we regulate political signs a little differently than we regulate, say, signs for special events. The impacts of the decision are still evolving, but essentially there's a overall effort since this decision came out for local governments to evaluate their sign ordinances, to look at what needs to be potentially revised to in light of this decision. In Indian River County's ordinance, and I just kind of touched on it, we do have certain sign definitions in our code that are content-based. We also make distinctions between regular temporary signs that appear to be inconsistent. This was brought and discussed to the Board of County Commissioners by Commissioner O'Brien, who became aware of the decision. And there was a discussion, and out of that, the focus of the County Commission's discussion was particularly focused on temporary signs, which was the specific signs that were the focus of the Reed decision, though it had implications beyond that. At the July 5th County Commission meeting, the board did direct staff to, in particular, to look at and revise the county's regulations on temporary signs that require permits, and also directed staff to just take a look at the overall code to see what content-based regulations need to be looked at for revision. So we've done that, and we've now drafted some proposed revisions, which we're bringing to the commission for consideration. There's three main areas that we found that looked like it needed to be revised based on the content-based issue. Those were definitions, permit exempt sign category that we have, and then the temporary signs with permits. Under the definitions section, which is largely in Chapter 901 of the county's land development regulations, we actually have 48 definitions related to signs. So there's a lot of definitions of different types of signs. Of those 48, we did find most of them were content neutral, such that they would describe what a freestanding sign is versus a facade sign. But there were some that were content-based definitions. And under the proposed revisions, we're just looking to eliminate those definitions. And the definitions we're talking about are listed here: construction sign, development sign, directory, political sign, real estate sign, and special event sign. Although these signs will still be regulated in the context of the overall ordinance, we felt it was appropriate to delete them as definitions because they are essentially content-based definitions. Under the next general category that we looked at, permit exempt signs, some examples in our current ordinance that we don't require permits for: traffic regulatory signs. I already mentioned real estate and garage sale signs. Although we don't require permits for them, we do have certain criteria within the exemptions that they have to meet to be exempt. Carried signs, non-commercial art. In order to meet the objective of the content neutral approach to under permit exempt signs, we're proposing a new category in the revisions. We're called temporary signs of limited geographic scope and number. And while it sounds like a mouthful, essentially the intent is to put a number of current category signs, such as garage sale signs and for sale real estate signs, under this category, such that we wouldn't be focusing on the content of the signs, but on the scope of the signs. And while we're making this category in the permit exempt signs, this kind of relates to, which I'll reference as I go on, that if it's beyond this limited scope, it'll be in a scope where you'll need a permit for it, but you could still get a temporary permit. Under this section of a new category, we'd still have what we do now, which is limited size and number of temporary signs. I'll just use garage sale signs as a reference. Like right now, you don't need a permit if you want to put up a garage sale sign, but we also say you can put up a sign at the top of your street or in right-of-way, provided you meet certain standards, and it's only up when you're having the yard sale, and it's only up for so many days. We're essentially keeping the similar requirements. We're just making the requirements essentially uniform for various signs regardless of category or content within this new category of limited scope and number. So that's the concept there. Also under the permit exempt sign category, we're looking at some revisions in the descriptions of signs to shift the focus from content to location. For example, it doesn't seem like a major change, but we feel it makes a difference. We have a category of temporary construction signs. We're now proposing to change it to temporary signs on construction sites. Also, free expression signs is another category we currently have for permit exempt signs. We're proposing to make those on-premise yard or window signs. Again, similar allowances without permits, but it allows more focus on neutrality of content versus content-based. The third category that we looked at and are focusing on some revisions are the temporary signs where we do require permits. And right now, under our code, examples of what we require permits for temporary events, for example, such as fairs, seasonal sales, shows, grand openings, concerts, political campaigns. This is when you'll see signs beyond just on the property where the event or is happening, but in limited in scope throughout the county to promote the event. One thing that we do now, which we're changing, is we do have a separate category in our code for political signs, where again we treat them a little bit different than we treat other temporary signs for events. So what we're proposing under this revision is essentially treat political campaigns and elections as essentially a type of event, so that all the events essentially have similar criteria that they would have to meet. The main thing that changes is the duration, and essentially the way the revisions would work, that the duration or allowance of time for display would be tied to the essentially the approved timing or the described timing of the event. So that's how we're proposing to deal with that. Finally, we do have some other revisions we're proposing. We have a separate category for temporary signs in our current code for active subdivision or real estate signs, where you have a new subdivision or development and there are signs promoting the sales within the development. The revisions that we're proposing, again, is to focus on eliminating the content-based references and instead focus on location. We're taking this opportunity to look at the ordinance on this particular category. Over time, right now the ordinance is really focused on the concept of within like a new development or new subdivision. The code right now allows authorized agent for the subdivision to put up signs like towards the entranceways. We're finding now of late with the larger subdivisions and developments, you'll have more than one authorized agent within the same subdivision. We've had occasional conflicts where we don't have, our ordinance didn't account for the different authorized agents within one subdivision, so you have one agent over the other trying to get their foot in the door to get their sign up. So what we're trying to do is accommodate that, so we're proposing some revisions that acknowledges and allows for more than one authorized agent within a development, for they can also each have signs. We are still trying to control the proliferation, however, so the threshold we're limiting that to would be an agent would have to represent at least 10 lots within a development in order to qualify for the sign. So there's a little bit of change there.
Roland, I don't even know. Can I stop you for 1 second? You know, that right there, I would have an objection to it. Let's just say you had a 50-lot subdivision and say there's only 5 lots left and you want to go there and build homes. You only have 5 lots. And you can't put your sign out front to let everybody know you're there, but all the other guys can. I mean, you know, you want to be able to put your sign up. I think if you are an agent in the development, you should be able to put your sign up.
Well, I think the concern we had, and I guess that's certainly for discussion, is if each lot owner had an individual agent, you'd have 50 signs out at the entrance. I mean, there's some level of threshold. If someone has 5 left, but they originally had more than 5 in the development, you know, we consider that an authorized agent.
Well, let's say that the person got in there later and there was only 5 lots left and they bought it and they still couldn't put a sign up. See, that's the thing. Which is,
Well, that's a good point, and
I don't really agree with.
Is this just relating to signs out at the front of the development as opposed to a sign sitting on a lot in the
Correct.
development?
yes, these are entranceway signs for the perimeter roads. It would still be a separate allowance for signs on the actual lot or say at the model home site.
I think in trying to look at those issues, you know, we're trying to accommodate more signs, but not too many, as Roland said, to look at, you know, you may have a builder that has, you know, 20 lots under contract. He doesn't actually own them, but he's got them under contract. You know, they can be taken down over a certain period of time. That would be an authorized agent. And I think one of the bigger questions, let's say you've got a 500-lot subdivision. Is there going to be a real estate sign until the very last lot is sold, the very last home is sold, for however many years that's going to be? And I think and so that, I mean, that's part of the discussion. How long do you allow these signs up? You know, you've got 499 people living, you know, houses occupied. How long are you going to have that there? So we're just trying to balance some things off. The 10-lot threshold is something that we've had in our temporary use permit ordinance for real estate sales offices in a subdivision, that you have to have at least 10. But like Roland said, you know, if you start with 10 or you start with 100, you know, you're an authorized agent until you're done with that. But ultimately, what we're sort of balancing off in the case of the signs, as well as real estate sales offices that are temporary in developments, is you know, how long are they there for? Are they there till the very last, you know, lot is sold or is built? So that's just something to keep in mind. And we can certainly come back and discuss, you know, this particular case. And I appreciate the question coming up during the flow of the PowerPoint.
Well, hey, I apologize. I've got a short memory.
No,
Thank you, Roland. I appreciate it.
No problem.
And just while we have that in front of us, the phrase active subdivisions, what does that mean?
well, that would be before they're built out. In other words, there's still development going on at the initial.
Is that defined any place, or is that just, we should know?
I don't know that that's defined any place. Active.
Mr. Chairman, I have about a page of questions and comments on political signs. Surprise, surprise.
Okay. Well, I'll tell you what then.
We'll come back
Probably
to it
this
at
point,
the end.
since we all have all questions, why don't we go ahead and let Roland finish?
Thank
Yeah,
you. That was
and then we'll come to.
Okay. I am close to finishing. The other revision we're making is just a cross-reference revision within our Chapter 912 under single-family development, which is kind of the catch-all chapter for single-family development regulations, where it references garage sale and yard sale signs and regulations. We're just revising it to synchronize with these proposed regulations within the sign ordinance. So that's essentially my presentation, and we're recommending that the board commission consider the ordinance for recommendations to the county commission. Thank you.
Thank you. So I would open the floor to any questions or comments by commissioners. Mr. Frost, would you like to start?
Thank you, Mr. Chair. Just for the record, those who don't know, I serve on your school board, and as an elected official, I have a little bit of experience with this, and as part of my day job, I work around the state helping folks get elected. So I deal with this in a number of municipalities. And this is something that came up, and it was a big change, and of course, it's something that must be dealt with in code. And I actually have a question for Mr. DeBrawl. Is this, or maybe it's for Stan, but is this basically the remedy that's been suggested by some body, whether it's the Council of Counties or League of Cities, as the remedy by recategorizing from content-based to a special event?
There are two different levels of scrutiny that a sign will undergo. If it's commercial speech, if the speech is based on the message, it's strict scrutiny. Like if the ordinance would regulate real estate signs, campaign signs, and I don't know, whatever. That if that ordinance is aimed toward the message that the sign is conveying, the government must have a really good reason to prohibit that sign or to regulate that sign. If we regulate a sign based on its location, whether it's on-site or off-site, it's an intermediate level. It does not have the strict scrutiny applied to it if the sign ordinance were challenged. So if you say, we're going to regulate this sign based on its location, okay, the government has good reasons for doing that. We don't want clutter, we don't want blocking of right-of-way, et cetera, et cetera. So there's the differential as far as why we're moving away from the message that the sign is conveying to the location of the sign.
Okay.
And Mr. Chair, just in point to your question, just in terms of ordinances that we've looked at the staff level, and you're right, there's been changes. Actually, a lot of local governments have been pretty slow to roll out the changes because it's difficult. You start trying to grapple with content-based. Most sign regulations have been content-based or are, up until this point. But the approach we've used, either looking at location or the time of year and that sort of thing, I believe that's what the city of Sebastian did when they changed the definition of the political sign. You have to read the sign to see if it has to do with politics. They changed it to election season signs, so signs that are temporary, that come about and are placed during when there is an election going on. So they tied theirs to the time of year, and essentially what we're saying here is we're trying to tie the common element between a lot of these types of signs, and we're tying it to the event. Again, the time of the event. If the event is county fair, then that's the event that sign is for, and it's off premises. If that sign is related to an election, that's the special event, and it's that time of year, and that's the event that it's geared towards. So that's the approach that we've taken here, and it's consistent with some of the other proposals that we've seen.
Okay, and I think that particularly the location and regulating that makes the most sense, because those in the campaign world really struggle with the idea of gypsy locations. They just stick them in the hedgerows at Publix and things like that. But has election season been operationally defined? Because I know folks who were just elected to the state house, and as soon as they came back from Legislator University, have filed to run next in 2 years. So to them, they're in election season. But is there anything in statute or ordinance that would operationally define election season?
I'll say a few things and turn it back over to our sign expert here, Roland. Each type of event is going to be different, and so I think the judgment call between the applicant and staff is going to be what event is this relating to, and what is the time frame for the event, and those time frames are going to vary. And you're right, we don't define a particular election season so much, but we do reference some time frames around the election. But elections can be special elections, there can be runoffs and that sort of thing. So I think we've got that covered, but I'll let Roland dive into the specifics of that.
Yeah, well, we used to, in the current ordinance, we would reference 90 days prior to the actual election. What we've found in, I think it was Osceola County's ordinance when we were looking at this, they did some revisions. Rather than just pick a specific period, What we ended up with, the language is in here, but it's essentially when it's the last day of qualification for the office, which is a reasonable time frame. It's not much different than the 90 days. It's actually a little shorter when you prior to the primary, but we just went with that. So as soon as you're the last day of qualification until the election, and then 5 days after the election to remove the signs.
And that's at the bottom of page 9 of the ordinance attachment that you're looking at. Duration of sign display restricted, and it's tied to the deadline for qualifying.
That's reasonable. It's good to see that level of thought given to this. And bringing it back to maybe Mr. DeBrawl, have these changes in tactics, if you will, been tested yet? I'm guessing not, since this is relatively new. We're just rolling it out, so we won't know what sort of legal challenge it'll face on the First Amendment challenge.
It's a 2015 case. The lower courts have tried to interpret, the case, and the governments have been now focusing on not content-based, but location-based. So, there's a little bit of a chess game that's going on. It appears that location is still the intermediate scrutiny, and that the government can regulate it more heavily, as long as you stay away from the content of the sign.
And only being a non-voting liaison, I didn't get a full packet. But as I breezed through the PDF today, I seem to notice that there was, on the commercial permitted side, there was a maximum of one sign. And that, or at least I believe that to be the case. So I'll just give you an example. At the corner of US 1 and 512, there's a car lot. And candidates, it's a corner lot, so you want to catch them in both directions. So I was wondering, or like my house or my dad's house, it has several hundred feet, thousands of feet of frontage. So to have only one sign, and this is in the residential, but to only be able to put up one sign on private property, it seems like a lot of regulation of private property rights.
Are you referring to temporary signs, like for elections, or for more permanent signs?
Temporary. All you're going to hear from me about is elections.
Okay.
Where is the provision that talks about one sign? Let's try to get that in front of us.
I believe it's at the top of page 10.
Sounds right. Yes. Yes, I believe it's 4A, for alpha. One sign per special event is allowed per parcel of land.
And it's a point well taken. If you look at what the current code is, one sign essentially per candidate or issue.
Right.
And in proposing to strike that through, when we talk about per special event, I guess the question would be if you've got a particular election, could you have a sign for each of the people that are participating in that's related to that event or not? And
I think the intent is to allow that.
It's a really good point that you raise. I think we do need to look into it. We're trying to do two things with respect to neutrality. We're trying to be content neutral, and we're trying to be result neutral as well. We're looking. We don't want to have fewer rights for someone, and we don't want to have an increase in the number of signs and so forth. We're trying to keep it. But that's a good point. I think we can look into that because we want to keep the kind of allowance we have now.
That's under the development regulations.
Okay, and that's 4 square feet on private.
Yeah.
And that's, a lot of folks, when what was it, Reed versus Town of Gilbert came down, they bought these supersized signs. I won't mention any names, but they're sitting on a warehouse full of these larger signs. I guess you have to do what you have to do, but I don't know. I just think that I suspect that this would face a challenge pretty early on in the legislative process. Not necessarily locally, but somewhere someone is going to raised the issue that they can't have, more than one sign for their chosen candidate on their private property in their home, or, on land they've purchased. And I'm just trying to provide feedback to the commissioners because this will go for a vote before 5 folks who are going to be experts in this area and have a lot of interest in how this goes down. So
yeah, let me just point out
I appreciate that.
That makes me remember, when you're on the issue you're raising on, if you look at both the permit exempt signs and then the special event signs, the permit exempt signs, I had referenced earlier a category of yard or window sign that's exempt from needing a permit. And I think that allows up to 4 signs if it's an on-premises yard sign.
That's good.
Non-commercial speech. So that's distinct and separate from the special event permit needed sign. So there is a little bit of play there as far as number of signs.
Thank you. Now, while we're discussing permits, in some municipalities, they require a blanket permit fee, basically the cost of the administrator taking down the notes of all the sign locations and keeping it on record and saying, yes, this is a legitimate registered sign location. In the fact that we're a nation that prides itself on free and fair elections, there may be, are there any plans at present to tie these permits to a fee of sorts?
Right now, yes. I mean, right now, currently, we charge like a $60 blanket permit fee for, say, a special event for a concert or something. We have been not charging that fee for political campaign signs, though we still required the permit so we could track and be aware of where the signs are. Under this proposed revision, more towards content neutrality, we would, as proposed, put that fee on political signs just like we would any other special event sign. So we would not be making that distinction any longer.
So the thinking would be that it would still be a nominal blanket fee versus, $10 per location or 60 cents per square foot or something.
No, it'd just be one blanket flat fee.
And with the assumption being that the event, if you will, is election day and the beginning of the advertising period being the end of qualifying or whatever else is operationally defined in ordinance. Okay. Thank you. That's all my questions, Mr. Chair.
If I could just follow up, and maybe you addressed this. I was sitting here trying to reread some of this stuff as the questions were coming. Special event as applied to an election. November 8th, we had many elections happen, federal, state, local. Within some local elections, there were multiple positions, for example, city council. So as applied to that scenario, tell me again, what is the event for which you're allowed one sign per event?
Well, under the event would be the candidate running for our election during the period where he first qualified, the last qualification day to run until the election occurred. So each individual candidate would essentially be an individual event. We've had, and then within that event temporary permit, you could have multiple signs throughout the county for that individual. Now again, this is distinct from someone who just supports the candidate and puts a yard sign, which they don't need a permit for. The permit, the temporary permit for special event is specifically for putting signs out, not on individual properties, but essentially within the right-of-way throughout the county. That's what the permit is for. And when it is allowed in the right-of-way, it's allowed in a certain specific location on the very outer edge, and we limit the number to 20. And again, we'd be applying that to all special events. But again, it's in addition to and distinct from even if it was a concert, a politician, doesn't matter. If they made arrangements for a private individual to put a sign in their yard promoting the event or the candidate, they would be exempt from that permit, and it doesn't count towards the permit we'd be issuing.
So just so I understand, if I'm a property owner and I support whoever for president and somebody for U.S. Senate, and there are 3 commissioners up for election, I can put a sign up for the president, I can put a sign up for U.S. Senate, I can put a sign up for congressman, I can put a sign up for each of the 3 commissioners running, I could put a sign up for 2 or 3 city council
I
members.
believe under these proposed, the limit is 4, under that.
What total?
That's
Yeah.
limiting speech. So you can,
Okay.
also, I heard something there that I hadn't heard before, read before. So a maximum of 20 signs. So if I were, let's say my PAC was out there trying to get the 1 cent sales tax renewed, and I wanted to put out signs, and I wanted to put them out in more than 20 locations, and I can tell you my database is much larger than 20, I would have to pay the $60 fee more than once, or that's it? I have to stop when I get to 20 signs?
20 is the maximum if you're putting it in the right-of-way.
In the right-of-way?
If you're putting it on private business property where they're okay with it, or a private individual's yard,
Okay.
that's a different category of
Right. You
allowance.
essentially would not be limited to the number of owners who would be willing, whatever that number would be, to put up the signs on their property, commercial or residential. But in the right-of-way, it's limited to 20.
Okay. So on your property, to Mr. Chair's point, he would be able to support every single candidate in every single election he chooses, so long as he is behind the right-of-way line? Or is it limited to 4 no matter where on the so on private property? I'm talking outside of the right-of-way.
Right. Per lot, the proposal is a limit of 4 on-premises yard signs displayed. That's page 8 of the ordinance.
Per one person's property.
Per lot.
So,
You're in my top 4.
so like going down
Bill? Yeah.
66 over there by the lake over there, where there was probably 30 signs going down the side of the property.
Yes, we're talking about legal signs. We're not talking about illegal signs that were placed there without permission and without proper permitting.
Right. I think the question is what is, first of all, should there be a limit? I mean, you're really talking about 2 things. Again, this is the hard part of trying to go content neutral. When we've been dealing with these election signs, you should be able to put up, well, how many signs on your lot for the same candidate?
That's a good question.
All 4? All 4 say the same candidate? 1 for each candidate running? Should you be able to put up 100? If you want to put up 20 of each of your 5 favorite, so the question is,
then you have the amendments on top of it.
Right. So the question is, do you want to limit temporary signs on commercial lots? Do you want to limit, special temporary signs on residential lots? If you do, and we think there should be a limit to limit clutter, what is the allowance? And what we're not used to doing is having to treat political signs like all other temporary signs. This is the difficulty, well, one of the difficulties of the Reed decision.
Well, I'm trying to quickly read this language that you're referring to on page 8. The non-election related signs on premises or in windows. What's the limit on the total number of those signs?
It's the same. We're trying to treat them the same. That's why we're having a limit. I mean, if you look at the cross...
Where does it say it's 4?
If you look on paragraph 2, subparagraph 2, number 2, you can actually see in the crossed out of the current code, it says you can have 1 free expression sign per candidate, issue, or topic. That's what it currently says. But because we're trying to be content neutral and not be treating any sign similar to a candidate sign, that's the proposal why we came up with a limit on number.
It's probably here, but I'm not seeing it because the only up to 4 on the premises or yard sign language.
It's during periods of election.
Yeah, but that's my point.
It says, it kind of limits it during, well, I understand what you're saying.
No, what I'm saying is that limit of 4 per yard or per premises is in a sentence that relates only to elections.
Election periods. It doesn't have to be a sign promoting candidates, but it's during that period. But I understand what you're saying. When it's not during an election, you can have as many as you want, essentially is what is I guess, the point you're making.
Yeah, I guess the point that I'm trying to understand is how many non, oh, I see what you're saying. You're saying during the period of election, you can have 4 signs that deal with any subject they want.
And during
but no more
periods
than
of
4.
non-election,
During
we
periods
don't
of
even have
non-election, there is no limitation on the number of signs.
Yeah, that's a
Am I
good
reading
point.
that correctly?
I think that's how it's written. So it is something we need to.
There's a lot that seems to need to be clarified. I mean, I can't.
I know, I understand you know, the staff has a very difficult job in dealing with this, and also the legal side of Reed v. Town of Gilbert. But it seems as though what's being done here feels like just a dodge of the First Amendment. Like, you know, kind of in my world where we had Common Core, and then we changed the name to Florida Standards, and then it's you know, we don't have Common Core anymore, but of course we do. So it feels like this is along those same lines of where these new ordinances would, I mean, pick your top 4 candidates. So you're going to have folks on the city council fighting for space. And I'll tell you, businesses like that. They like to support winning candidates. I'll tell you that straight up. So I think that this would probably be a straight vote down. And again, I don't know what conversations you've already had with the commissioners, but this, you know, this seems like if it were to pass, it's going to face an immediate legal challenge because you're, especially if the word during an election period is in the limiting factor of having 4 messages no matter what, whether it's, you know, 50% off burgers at Sal's.
Let me ask you this. Is it your opinion that, and obviously the rest of you all want to hear from you, is it your opinion that, you know, right now, pre-read, we allow one, what was in, free expression sign per candidate or issue? And is it your desire that result remain? In other words, that on any commercial lot or any residential lot, that 1 sign per candidate issue or topic be allowed? And in doing so, and listen, this is good to have discussion on. This is why we have to roll up our sleeves. Maybe we need to come back to you guys after looking at some things. But I think if that's the case, then the way you're looking at that is that each candidacy is an event.
I don't think that's unreasonable.
Oh, and I'm just in terms of trying to put
that's a good way to operationally define it.
Trying to put, you know, each amendment is an event. But that's the result that you're talking about, and I'm not sure if the rest of the P&Z is of the same
right. And
same opinion.
I would say that perhaps 2 in certain situations where you have a corner or a frontage more than 500 feet or something along those lines.
Look at, for instance, I have a piece of property on 512. It's got an eastbound lane and a westbound lane. So you're going to tell me I can only put, say for instance, Sean wanted to run again. I can only put one of his signs on one side of my property. I can't put one on the westbound lane and the eastbound lane so people can see him coming and going.
We can put whatever the board adopts. And the question is, how many signs do you want? How many temporary signs do you want, and how long? I mean, this is a trade-off. You could say forget limits, forget sizes, put as many as you can. But you know, obviously, what we're trying to do is keep the regulations we have now, the results the same as what we've had going into this. That's except for the real estate sign item that Roland already brought up.
I guess the question I have is the intent to satisfy the lawsuit issue, the case, or the intent to satisfy a clutter issue that some people may have, which which then lends to, you know, a right of free speech for a client. But a suggestion that I would have potentially for this is you have it in the real estate signs. If there's a certain amount of frontage, there's an allowance for additional signs. I mean, so for example, you've got 1,000 foot of frontage and I've got 50 foot of frontage and I have 4 signs and you have 4 signs. I mean, you don't have the clutter issue that some people may perceive, but it's a suggestion. But you know, the number of events or elections that are available is an allowance as well. But you know, we all know that, I mean, the corner of 43rd Avenue and 60 on a commercial piece, there's more than 1 sign there. There's more than 10 signs there in a lot of cases. So I guess the question is, what is the intent primarily? And that helps address a potential answer to it. But
yeah, again, the intent is to satisfy the case, you know, and to keep the result the same as it is now. We don't have more signs, we don't have fewer signs, with the exception of the real estate sales sign, recognizing that we have multiple builders, especially in larger developments, actually allowing a few more signs on larger projects. What you're mentioning, and Mr. Brogdano mentioned, was maybe even for the temporary signs, you should look at the size of the frontage and not per lot basis. That's what I'm hearing on that.
And I guess one of the questions I'm continuing to struggle with is, if I understand the election, and again, we have this whole question of, does that mean per candidacy, per whatever, but the election would now be treated as a special event. However, if the special event is an election, then you have this rule about a limit of 4 signs. Are any other special events singled out for special treatment other than elections? Because if they aren't, then I'm thinking you're right back to a content-based regulation. You know?
Yeah, I think we need to treat events the same in that.
I'm thinking if you, at least, again, I haven't studied this issue from a legal standpoint, but right on the surface, I would think you ought to just take out the election concept and treat all special events the same. And whatever those rules are,
Well, again,
they apply across the board to all.
This section that we're focusing on right now under page 8 is not under the special event category. This is permit exempt signs any time of year.
Okay.
And I think the intent of staff when this was drafted was you can have an on-premise sign, a window sign that meets certain size requirements, etc. Any time of year, we don't care what the content is, as long as you meet this criteria. We actually are thinking about it in an opposite direction. We're thinking during periods of election, an individual might want to have more signs during that period than normal, because typically we wouldn't expect someone to have 4-yard signs throughout just any particular time in their yard for whatever reason. So the intent was really to allow more signs during the period, not less. But it sounds like as we talk about it, it's resulting in a limitation that we weren't anticipating. So, and again, like you said, we're actually making a distinction based on election that maybe we shouldn't even be making that distinction. So,
Yeah, that was more signs up to 4.
yeah, that was what
Yeah,
we were
and
thinking. But
that,
now,
that's a problem.
yeah,
That's a problem because, you know, I can't envision a scenario where you support every candidate that's running, but you want the option to support more than 4.
right. I mean, to keep it as it's currently allowed, that's the challenge. If we were to say during election period you can have as many signs as you want per candidate, then all of a sudden you're getting into content-based allowance. So that's what we're trying to deal
But
with.
Stan, I think it goes back to what you were flirting with, where each election is an event.
Right. And just to kind of picture in your mind what we're talking, let's just imagine a residential lot. We're talking about a yard sign. And I think the intent is that all through the year, you could have one sign, you know, no more than 5 feet in height, you know, a couple square feet, 9 square feet, and that sort of thing. And it could say whatever it wants. Let's say if you drive in South County, you might be familiar with don't 5-lane 43rd Avenue. You might have that up 365 days, which is fine. That's your one sign on that lot. But during election season, during a certain period of time, you could now have as many no 5-laning 43rd Avenue signs as there are candidates on the ballot, right? If we go to each candidate, every little option you have on the ballot, we're going to allow that many signs on a lot, unless it's a bigger lot and has a lot of frontage on a major road. Now you can have twice as many as there are choices on the ballot. So see, this is what we're getting into here is we're saying on a residential lot, you can have one sign of a certain size, except you can have more during an election season, and we define that. So there's a specific period of time you can have more. And so based on the discussion we've had so far this evening, I think it's the opinion of the commission to want to allow for however many on a say a residential lot, as many issues or candidates there are on, races that there are on the ballot. That's how many you should be able to have a sign for each one of those during an election season.
Well, but I mean, the example you gave a moment ago was a one-issue sign that you put up 30 times because there happen to be 30 elections. To me, I'm kind of where Dr. Day is. It comes back to the definition of special event. If the special event is essentially defined as a candidacy or an issue, you can have a sign pertaining to that candidacy or pertaining to that issue. One for every one of those candidacies. So you might have 30 signs, but one sign would say elect Jones, the next sign would elect Smith for the House, elect, Bowling for county commissioner or whatever. Mosquito control district.
Hospital district.
I fully appreciate this. This is, about as thorny as you can get, trying to dance around the First Amendment in a political context, which there are a few areas more protected. At the same time, trying to, have a community that's not overly cluttered with signs. I fully appreciate how difficult it is. But at least my gut feeling so far is if we're putting elections into the category of special events, then a further sentence or two defining election for the purposes of this special events definition, amounts to a voted upon candidacy or issue, then you can have a sign relating to that candidacy or issue during the election season. Just like I'm assuming any other special event signs are limited in duration, again, someplace in here, to the time period of that event.
Right.
So the time period of an election event would be the election season, and you've chosen a definition here, which I guess makes sense. Personally, I'm kind of wondering why it doesn't start as to that candidacy when the candidate qualifies, because from that moment, that person's qualified for an election. But that's
everybody starts the race at the same time,
Right,
I guess, right?
Yeah. I don't know. Those are just off the top of my head thoughts.
No, and I appreciate that.
Mr. Chairman, if I understand you correctly, what you would be saying is that on my single-family lot, I could have one sign for every issue that's on the ballot. In the last ballot, I could probably think that there were 25 issues, 20 issues, that you'd want to allow up to 20 signs or however many signs, an unlimited number of signs.
But isn't that what the language that you're eliminating reads? One free expression sign per candidate, issue, or topic is allowed per lot or parcel of land. I mean, isn't that where we are today? I don't
Yes.
know. Is that what you guys are political sign people? I'm not.
I mean,
Well, and then, to further complicate things, is a sign, one sign equals one disclaimer? Or like let's say we had two candidates running in one district in Escambia County where we had the county commissioner and a school board candidate. And the ruling there was that they couldn't stack up and use their 4 feet together, or 16 feet, 4 by 4. So then the question becomes, and also, is it two-sided or is it message? Are you talking square feet of message or are you talking square feet of surface area? And is that surface area, if you have 32 square feet, you have what? 4 by, no. Anyway, so are we talking surface area or are we talking?
We're talking surface
two-sided?
area. If you use two sides, you can have at it. So in this case, we're talking a 9 square foot sign. You can use both sides of the 9 square feet. I mean, that's the intent. And again, we're trying to get away from content. So during the period of allowance, you could have whatever you want on the sign.
So 9 square feet would be, you could have a 3 by 3 with candidate A on this side and 3 by 3 with candidate B on this side? Two
Yeah,
disclaimers?
on two sides. I mean, we've run into issues where someone, if it's straightforward if you have two sides of a sign facing traffic, but then you start V'ing it out.
Right.
And then when does it become more than 9 square feet or two signs? So we've had to deal with that, but we don't get into that specificity in the ordinance, but we have policy. Essentially, if it's two sides of a sign, it's still 9 square feet. Once it starts being out 9 and 9, it's twice the size and not allowed.
We're looking at the display from, displays, for instance, from a passerby, what they can see at any given direction.
Okay. So you could stack two candidates, in theory, on one sign because you're not worried about content, right? Since we're in compliance with the First Amendment, it could say, well, you can't do this because of election laws, but if there were a commercial, actually, anyway, let's just keep it within the specific event of an election. You could stack two candidates with two disclaimers as long as you stayed within, because the county is not concerned with the message or content. Right?
And you could get extra value if you have two candidates that share the same last name during the same election.
Yes. It doesn't happen often.
Stan, if I understood correctly what you said earlier, essentially what you're trying to do is convert from any content-based language over to location, et cetera, and otherwise try to not change the substance of where we are today.
Correct.
Okay. Now, where we are today is in an election, you can have one sign per candidate or issue or topic. Correct?
Correct.
Okay. So if you just defined an election as a special event, and then within that defined election as, a candidacy or, an open position or an issue or a topic upon which a vote will be taken during the election, and you can have one sign for each special event, which is, again, a candidacy or an issue on which a vote is being taken. Aren't we right where we want to be?
I think you're right. I mean, I've taken notes. I think it's an interesting concept. I'd like to think it through and see if that's...
And I'm not 100% sure, that's for sure. Like I say, I'm thinking off the top of my head.
And I'm perfectly happy with this issue for us to go back and take a look and come back to you all, continue the hearing and come back with some language, because I think it works the way that you're suggesting, but I want to look at it and think it through. Because this one, you really have to look at it from a lot of different angles, which is why I'm glad we're getting all the input we are from you all. It's more than just us and the county attorney's office.
Well, let's do this, because I'm hearing that you do intend on that issue to probably go back and think a little bit more and come back with something new. Are there any other new thoughts or different thoughts that any commissioner would like to express to staff on that issue that perhaps has not been expressed so far?
Yeah, one of the things that I tried to do and was not able to do with the Reed decision is to go back and see how that would have played into these modified ordinances. So the Reed decision was that a church had a rotating venue, and one week it would be at Oslo Middle, and then the next week it would be at the Flick. And so each week they put up signs directing people to where it was, where that was. So with this new ordinance, would those be permitted signs to begin with? would there be a permit required for those signs?
It depends on the scope. If they have, under our section where you don't need a permit, or under our new category of limited in geographic scope and size, if they met that criteria where, say, they only had like one or two off-premises signs in the right-of-way to direct to that particular location, they could potentially qualify for not needing a permit under the temporary signs of limited scope and number. If they wanted to put up more signs than, say, a couple at the top of the street where their location is, they would have to get a permit for the temporary special event. And that would allow them to have more than the couple of signs, up to 20, within rights of way for direction, basically. So it kind of depends on the scope.
So with the also middle idea, you'd maybe want, is 2 a hard number? Is it 2 signs and that is it?
I'm thinking that's what,
Yeah.
I'm pretty sure it is.
So,
under the
I mean,
limited
you'd want, if it was at Oslo, you'd want probably a sign on Oslo East and West, and then a sign on 20th,
Or 20th and 5th Street, southwest.
East and West, so that's 4. So that then becomes a permitted sign issue?
Yeah, again, under the, don't need a permit, you can have 1 sign per street frontage of the property that you're on. And then, as far as off-premises signs, let's see.
Get 2.
I think, was it 2?
Glad you're having as much trouble as I did.
Yeah, 2 additional off-premises signs. You can have 1 per street frontage of the site where the church service would be held. And on top of that, you can have 2 additional off-premises signs, like say at intersections leading to the property.
And that's non-permitted.
Yeah, we'd not need a permit to do that at any time they had a need for it. If they wanted to go beyond that, you'd have to get a permit, you'd have to define it as a special event and meet the criteria that we were talking about.
So for their situation, they could make it work easily as a non-permitted, under our ordinance. It would work easily.
I think.
Yes, as long as they don't need to broadcast it countywide where they're having their service that particular weekend, yes.
Are there, forgive me if I missed this, but are there penalties or fines or anything associated with all of this? I know that in many cases there are, but let's say that someone had 22 signs out and only had a 20 sign permit. First of all, going around counting signs is going to be fun, but so what sort of penalties and financial damages?
We have different
Are we looking at?
approaches that we've taken. The first approach is if a sign's where it's not supposed to be, we'll just take it and it's gone. The other would be if it's an ongoing issue, we'll issue a warning. We can issue citations and fines per sign. It can be up to $100 per sign per day. If it becomes an ongoing issue and it's just ignored, the warnings. So there's different levels of enforcement.
Some ways, that's kind of tough to regulate. Say you have a commercial piece of property and people start dropping their signs on your property without your permission, and you're writing me a citation. I have to sit in my property in a lawn chair and watch all day long.
And candidates do that, by the way.
People do that a lot.
Sure. No, I think what Roland's saying is, if it's, first of all, if it's in the wrong place, we would just confiscate it. But if it's on the property and the property owner isn't aware of it, the first step is to contact them, right? But not, we don't go in and start writing citations right away.
Let's just say you contact me and I go out and move the sign, and I'm sure if you see another sign up there, you're going to contact me. Eventually, you're going to write me a citation because you're going to get sick and tired of calling me.
Yeah,
You're going to call me every time.
I actually don't know that we've had that issue in all.
Or does the citation go to the event sponsor or which is more reasonable,
That's where it should go.
right, than
Right.
to the property owner to where, you know, where the sign is located.
Yes.
So I don't know if we
Yes,
need to put that in the ordinance, that the fines would go to the event sponsor, or like, you know, campaign.
It's typically whoever pulled the permit, or
Okay,
they would be the ones who would be subject to
Okay, so
the
you're up-
potential
okay.
Right.
penalty.
Right.
Anything else on political signs? So if not, Mr. Brognano, do you want to go back to your issue, or have you satisfied that issue?
Well, I have another one too, so can I?
Okay,
do this one
yeah.
first? Okay.
Any other issues other than political? I'm assuming we've talked out the political, and you can take that and go forward and try to come
Yeah,
up with
yes, and then
something.
come back, yes.
So are there any other issues that we want to address as well?
Yes, on page 7, the very bottom, regarding construction signs, it says, very bottom, it says temporary construction signs on construction sites. Temporary signs on construction sites may be erected upon issuance of a site construction permit, subject to the compliance with the following conditions. Character of sign shall not exceed a cumulative area of 16 square feet, and no more than 3 such signs on premises shall be permitted. Such signs shall not be illuminated. These signs must be located on a developed premise at least 5 feet away from all right-of-ways and at least 20 feet away from other property lines. Well, that's kind of one issue right there I have. Why don't we just say keep the signs out of the right-of-way? Say, for instance, you only have a 4 square foot construction sign. You kind of want to keep it close to your easement as you can, because you want to keep that area open for construction purposes. Material deliveries, dropping off trusses, framing packages. If not, your sign's going to consistently get destroyed if you can't place it towards the side easement, and keep it out of the front easement, not the side easement.
If I could clarify, so your concern is the 5 feet from all rights of way, you like it to be?
The 20 feet away from property lines, because there's a lot of places, you go into the city of Sebastian, it's only a 10-foot side easement, so generally speaking, we come our 15 feet from the road, we come the 10 feet off the side, and we put the sign there, because it keeps it tucked over to the corner. But according to this, I got to be 20 feet away from that side property, which projects it further out into the property, which limits my construction.
So it's a 20-foot, you're suggesting 10 feet is more workable?
Well, just out of the easements. Because there's some places that are going to have 5-foot setbacks on the side, maybe 10 feet in the front. All lot sizes are different. So I would say just kind of keep it out of the easements. And I think that would definitely help you, because you're not going to have people putting their signs in the easements. It's not going to affect you in any way in case you have to get into that easement to do any kind of work. And it helps us because it frees up more of the property to stage our construction activities.
Now, that change, if I'm understanding this correctly, the purpose of the ordinance is to meet the case requirements and take away content and
Correct.
go to other criteria. And in that provision that you're discussing, the only thing that's been changed is you changed the word construction sign to temporary sign.
Correct.
That's
I
correct.
understand that, but as I'm reading this, Mr. Chairman, I'm looking at this from a construction standpoint, that if we're opening this up for change, that's something that really would help people in construction, is if you could take those signs and keep them just out of the easement line so you can free up more area for construction. Just because we're doing this because of a Supreme Court case doesn't mean that we can't effectively change some things that might really need to be changed while we're here.
And I realize that, but I guess the thinking that I have is, if we start going into the substance of the provisions, we may get sidetracked off the purpose of the ordinance, which doesn't mean that there aren't provisions, substantive provisions, that need to be addressed. But that may be better addressed by coming back at a subsequent date to look at the ordinance on a substantive basis and see if there are things that we should change. That's just my thinking, and if there's just one thing that you want to talk about like that, that's fine, and maybe we could address it in the context that we're in. But if we start heading down the path of, and over here...
That's just one thing I had, that's it.
Okay. Because we will get sidetracked if we start getting into the substance of the sign ordinance. That's going to be an undertaking, I think.
Yes.
Okay.
Thank you.
Any other issues that anybody would like to address?
A question I have regarding the open house signs, because staff has, as item C, interjected some additional criteria in here. One that you had mentioned was the less than 10 lots issue.
What page are we on, Mr. Williams?
10 lot issue, open house. Stan, help me if you wouldn't mind, or Roland.
Oh, is that page 11?
No, it's before that.
So I am seeing such sign for each authorized agent.
Yeah, that would be.
Page 11.
Yeah, that's section 4, number 2. Because there is an issue regarding that, and I understand where the staff is coming from, because originally there was only one sign that would be allowed as it stands now, and then the developers put 2, 3 builders on that one sign. And I know that builders aren't necessarily happy with that in some cases, but when it's less than 10 lots as they are, and that individual's coming in and picking up the balance of them, he wouldn't be allowed a sign at all, a permanent sign, because the builders in most cases will go ahead and leave the lots. They'll leave their signs up regardless of their completion, or it's been completed. So that was one question that I had, that, you know, where did that number come from, the 10 lots? That was question number 1. And then question number 2 that I had was regarding the 18 days, this is page 6, the 18 days for a display of open house signs. That may not be practical from a lot of different standpoints. One is that, you know, that Saturday, Sunday, that's 9 weekends, and that's probably not going to be sufficient in some cases. And then how do you actually monitor that?
Okay, if I could take those two questions.
Sure, let's-
First, start on page 11. The question of where and you're correct, we're actually increasing the number of signs that can be in an active subdivision, recognizing there can be multiple agents. The 10 lots comes from, it matches the 10 lot threshold for a temporary real estate office in a subdivision. And I think the balance there was at some point, when is a subdivision built out to the extent that it's truly residential, and you're not, you know, you really don't want to be promoting a real estate office in a now a 90 whatever % residential area. So that's the trade-off there with having some minimum number, and 10 has been the number in other parts of the ordinance. So that's where the 10 came from on that. Again, trying to match it with something that we already have. And on page 6, I think the question is, when we're putting together all these different types of content-based definitions, including open house or what have you, and we put the number of days that's allowed for any residential site open for inspection or visitation by the public, that could include the 18 days. I think the idea there was to be similar to like 3-4 day weekends for an open house, that sort of thing, per year. But I don't think, and Roland, correct me if I'm wrong, I don't think we have anything that's exactly parallel anywhere else in the code with the 18 days.
No, I mean, one of the things we looked at, like Stan said, when we're trying to combine some current categories into one and come up with uniform timeframes, you know, we were also looking at, for example, garage sale signs. We don't want folks to have garage sales every weekend, because it gets away from the concept of being incidental to a residence. So we looked at the limits we had for those, but we also looked at, for example, what you're bringing up, say real estate signs, which, so that was our challenge in coming up with it. Right now, for example, on garage sale signs, we actually have a limit of 9 days per year. This would expand that to 18. So in some respects, we're being more flexible under that category, but again, I'm trying to uniform it as a non-content based thing. That was our number we came up with, to try to accommodate real estate sales and also garage sales, but to do it within a some limitation.
It's a practical concern because if you have a smaller builder who's in a neighborhood with, he only has 5 lots, he has a model home sitting there / spec home, he's going to be limited to an open house sign because he can't use a large sign, a permanent sign. He'll have a small open house sign and he'll be limited to 18 days. So I don't know, I mean.
Is that correct?
But I think what staff was trying to do is balance the residential character of the subdivision versus the, non-residential, where there aren't very many people living there, and where if you have people that see the multiple signs and take a drive through the subdivision, nobody's really going to care because there aren't that many people living there. But if you have the big signs that are going to attract people that aren't interested in the least to buy anything in there, they're just being nosy and driving around in the subdivision, why have those signs ruining the residential character of the subdivision itself? I mean, the residents wouldn't want the people that just enjoy going to an open house or whatever event might be taking place. You're just ruining the residential character of it, and that's the balance that I see staff trying to do by prohibiting the number of signs that you have out there. So you don't have little kids running around with essentially non-essential traffic coming into the subdivision?
Well, I mean, if there's no gate on that subdivision, it's open, people can drive through there anyway.
Correct.
So we're not really stopping that. What we're doing is we don't like signs. And if a guy's got, say, $60,000 a lot invested, he's got $300,000, plus he's got another $350 in a model, he's got $650,000 invested in a community, and you're telling him he can't say, hey, I'm here, with a sign out front. Or
Right. No,
a permanent sign fixed in the front yard until...
It's a balancing act. The seller wants traffic, the resident doesn't. And at what point do you try to balance that off? I mean, yeah, it's a basic conflict of interest there that we try to balance out.
Just as an aside, I was in Louisville, Kentucky, before the election, the week before the election. They allow 0 temporary signs. It is as if the election never took place. All the advertisements had to be on existing signage, existing billboards, things like that, or bumper stickers.
Yeah, that reminds me of a question I had earlier that I'd forgotten about. There are homeowners associations that can restrict signage completely, right?
Yes.
Yes, it'll be interesting to see if REIT applies to private deed restrictions or not. I don't know the answer to that. I'm sure there'll be a lawsuit.
Yes, they can, and private subdivisions also can regulate the size and type and number of for sale signs. I don't. Do they allow them in Windsor and Johns Island?
No.
Likely not Windsor and Johns Island, but that's Windsor and Johns Island too. So.
Well, and they don't allow them, and signs are not allowed in Point West. The signs are not allowed in a lot of communities, I mean, regardless of the price range. And people are happy with that until they want to sell their house, and then they have an issue.
But those are voluntary contracts into which they're entering when they become a member of an HOA.
Right.
Yes. I mean, we're not necessarily talking about the county at large, which is the jurisdiction of this commission.
That is correct. In other words, like all of ordinances, this ordinance is countywide, and private restrictions, or really in the case of deed restrictions, property rights that all hold, you have to meet both if you're in that subdivision.
But it does go back to if you have a community that doesn't have a deed restriction regarding signage, then those last 5 lots, granted the existing homeowners are not necessarily thrilled with somebody having an open house in there, a builder's spec house that he's trying to get rid of, but you're not allowing him a large sign, okay, but you're also restricting him on having an open house every weekend as he normally would.
In essence, turning this commission into a de facto HOA.
Yeah.
Of sorts. I mean,
I stay away from being chairman of any HOA, so please don't do that to us.
And I have been and would not ever do it again.
Well, then I think if the concern is you've got 104 lots, you can have 10, 8, you can split up into your 10 lots. What about the poor guy that gets the last 4? Then I think what you're advocating for is what we have here plus 1. If you're concerned about somebody not getting
An opportunity, fair
Right.
opportunity.
Right. You got a fair opportunity.
Anything more on that issue, since this is going to come back to us?
I'd like to see staff do something to accommodate that plus 1. We come back again.
Any other issues that have not been raised so far? I just have one last question, Stan. You and your staff are much more familiar with these changes and the purpose behind it. Are there any other instances in this proposed ordinance where you and your staff have said to yourself, wow, this is a significant change from our existing practice, and it could be harmful to our community in some way, or it could lead to the things that our sign ordinance is designed to prevent?
Yeah, we've asked ourselves that, and Roland and his staff have looked at it, what the proposal is that you all are looking at tonight to see, are we opening up a huge loophole or a door over here? Are we restricting or squashing something down over there? And our look right now is no. We'll get a chance based on the input that you guys have given us. We'll take another look at it and see. That's why we really have tried to be narrow in the focus here and try to take all those things and be sign effect neutral. We haven't hit the mark yet, quite, but that's what we're looking to do.
I mean, it is a very, very difficult thing to do.
Happen all at once.
Okay. Anything else then on this issue, on this agenda item? Okay, it's a public hearing. It's a legislative matter. I will go ahead and open the public hearing to any member of the public who wishes to be heard on this.
We have time for all audience.
That's right. Okay, just line up, sign in. I'll tell you how. Okay, no one coming forth. We'll go ahead and close the public hearing. Okay, that completes agenda item 6A. Item 7 on the agenda is Commissioners' Matters.
Mr. Chairman, the only thing that I would ask, if you want to continue the public hearing and have staff come back.
Okay, so you don't have to re-advertise?
Yes,
Right,
so that we would not
okay.
have to re-advertise.
In that case, I, as chair, will simply, the agenda item is coming back for further discussion, so we'll go ahead then and continue today's public hearing rather than close it.
Thank you.
And Mr. Chairman, do we need a date certain for the continuation? I would
At staff's pleasure.
I would recommend the January 26th P&Z. That'll give us time to take a look. That would be when we would look to be bringing it back.
Very good.
Okay? Everybody okay with that?
Yes.
Continuation of January 26th? Okay, in that case, I will continue the public hearing until our next meeting, or our meeting on January 26, 2017. Okay, next item on the agenda is Commissioner Matters. Does any commissioner have a matter they would like to raise?
What about the affordable housing representative?
Well, that's actually item 8 on the agenda.
Oh, okay.
That's the way it's set up on the agenda. Okay, no commissioner matters? Okay, we will move to item 8, which is a planning matter, consideration of an appointment of a planning and zoning commissioner, a commission member to the Affordable Housing Advisory Committee. Mr. Bowley?
Thank you, Mr. Chairman. The Affordable Housing Advisory Committee tends to meet once every 3 years. They can meet more often than that, but once every 3 years has been their pace of meeting for a triennial review of housing policies. It's in the Affordable Housing Advisory Committee rules that a member of the Planning and Zoning Commission, our local planning agency here, should serve. And we've had, in fact, the last Planning and Zoning Commissioner who served was Maria Calderon, who's been replaced by Chip Landers. And so we do need the Planning and Zoning Commission or somebody to volunteer, and for the Planning and Zoning Commission to accept that. And we would have them assigned to the Affordable Housing Advisory Committee, which will meet, we believe, once in 2017.
The agenda item does say that the purpose of the committee is to triennially review the county's policies, procedures, ordinance, it says land development regulations and comprehensive plan to recommend specific changes to those items or consider various initiatives to encourage or facilitate the provision of affordable housing. So I guess the first question I'd ask is whether any member of the commission has special expertise or interest in the issue of affordable housing in our community.
Chairman, I do have special interest in it. I actually previously served on this committee quite a long time ago, and we do support one Habitat for Humanity as well, and I actually work on their houses almost every Saturday morning, so I would have interest.
Very good. Do we have any motion then? This is an appointment that we make as P&Z?
Yes, yes.
Okay. Do we have a motion to appoint Mr. Landers to the Affordable Housing Advisory Committee?
Motion to appoint Mr. Landers to the Affordable Housing Advisory Committee.
Mr. Brugnano made the motion. Do we have a second?
Second.
Yep.
Okay, I think Mr. Rednower started the second, right, a split second before Dr. Day, so we'll accept that second for Mr. Rednower. Any discussion? If not, all in favor of the motion, please signify by aye. Aye. Any opposed? Hearing none, that motion carries. Thank you very much, Mr. Landers, for volunteering for what is a very important position. Okay, that brings us on the agenda, item 9, Attorney's Matters. Mr. DeBrawl?
I have none, sir.
Do we have anything else to come before our commission tonight? If not, thank you all for coming, and we'll go ahead and adjourn the meeting.